Welcome. Today's video is going to address the topic of funding your trust. If you already have a trust or if you're considering a trust, it is important for you to understand what the process of funding your trust is, what that means, and we're going to get into the details right after the introduction. Congratulations. You're either considering a trust as the main part of your estate plan or you already have a trust. Now, if you have a trust and you've executed it, the most important thing you're going to do in order to make your trust an integral part of your estate plan is to fund that trust. Funding a trust is the terms that we use to describe the process of transferring all of your assets to your trust. It is important that all of your assets be owned by your trust, at least as of the time of your passing. If assets are owned in your individual name and you pass away, of course, that those assets may have to go through probate. So the process of funding your trust is important in order to make sure that your assets don't go through probate. However, there are more advantages to a trust than just avoidance of probate. So one of the things you need to remember as you're going through the process of funding your trust, that those advantages are only attained if you have those assets transferred to your trust. Now, what funding means for any individual asset or property is going to depend on what that property is. And I'm actually going to walk you through the process of what that means by showing you a form that we provide to our clients in the process of funding their trust. So to begin, let's open up the form. Before I begin, a real quick word to my clients. What I'm going to discuss is going to sound complicated, but you have funding instructions. Those are the funding documents, letters, assignments, deeds that accompany this checklist. You won't have to fill those out. Those will be completed based upon our conversation, either by telephone conference or Zoom, regarding your funding choices. If it seems complicated, it's because I'm discussing funding generally, and I'm really providing options for those people who haven't had a conference with an attorney, are checking to make sure that their choices were done correctly, or are trying to do it themselves. So please don't let the following complexity confuse you. This document that I'm showing on your screen is called a funding instructions checklist. And it's what you're going to go through when you first obtain your trust in order to make sure that everything is in your trust. We start with your real property. You should have received in your trust package a deed or a series of deeds for all of the real estate that you own. And this instruction checklist is going to walk you through what you need to do. Of course, at the time of signing your trust, you're generally going to execute those deeds, and you'll be able to then check that first box indicating that you've executed them. But this checklist reminds you that there's an additional step that you need to take, and that is that those deeds do need to be recorded. They need to be taken down to your county recorder's office and actually filed with the recorder's office in order to be effective in transferring your property. Now, if you are doing that yourself, then you're going to take that down with any forms that we've provided you in order to make sure that your trust is funded. If, however, you're going to have us record those deeds, you're going to return those deeds to us. Normally, we're going to provide you with an envelope in order to send those back, but if we haven't, simply deposit them in an envelope. We do need the originals. Now, if you don't have any real estate, you don't own any real estate, you've transferred it, you're a renter, or there's some other situation, then you're just going to indicate that that's not applicable. Now, along with interest in real estate as an owner, there are also interests that include oil and gas leases, land installment contracts, rental agreements, mortgages. Sometimes you'll have farming agreements or other contracts that affect that property. And generally, we want those to also be included in your trust. And so we want to execute documents in order to have those transferred. If you have an oil and gas lease, for example, we're going to provide you with an assignment that you're going to send to the oil and gas servicing company, and also in an appropriate situation, record in order to make sure that that oil and gas interest is a part of your trust. Land installment contract, same thing. We're going to have those assigned to the trust. And again, you go through the process of having those documents drafted, then you execute them, and then you need to record them. The next set of assets are all going to be financial assets. And we start with number three there, which are banks and credit unions. Those are checking accounts, savings account, CDs, money market accounts, and the safe deposit box. We will provide you with a form that you're going to take to the bank in order to get all of those transferred. Now, you need to take one form to every institution in which you have any of these accounts or in which you have a safe deposit box in order to make sure that those are transferred into your trust. You're going to deliver them. Then you're going to make sure that they're included by looking at the statement that you receive on a monthly or quarterly basis that indicates that that account, that investment is in your trust. Now, the next accounts are all those accounts that you might have with a broker or financial planner. These days, that may also include your bank because some banks do provide for either insurance or investment services. In that case, then you're going to have the same form that you're going to take to your bank. But if it's somebody else, if it's a broker or a broker dealer or some other institution, you're going to take a form that transfers those accounts to your trust. You're going to deliver it, then you're going to verify that that's been done by, again, looking at the monthly or quarterly statements. That's how you know that the institution has followed your directions and transferred the assets into your trust. The next set of items are stock certificates or any type of investment certificate. With these, we're going to do something very specific depending upon what it is. Normally, it's going to be just a transfer, but you will need to prosecute that with your broker dealer. Oftentimes, we're only going to give you an initial instruction letter that's going to start the process because, in addition to filling out forms, you're going to have to do a W-9, and you're probably going to have to include what is a stock transfer power of attorney for whoever is going to prosecute that for you. If you have a broker, the broker is going to provide you with all that you need in order to accomplish it. It's one of the reasons that you pay that broker is to process that type of administrative transfer or a purchase or a selling of stock. They will do that. However, if you have stock certificates in your home, meaning that you've purchased stock directly from a company, the best example of that these days is usually a community bank, a small community bank in which you've purchased shares in order to keep that bank local and to keep that bank healthy. Great idea. But you do need to transfer those stock certificates into your trust. The next set of assets are savings bonds, and those are going to best be handled by simply sending us a copy of all of your savings bonds. The reason for that is that we actually have to process that transfer through the Department of the Treasury. And the Treasury Department has specific forms that they want us to fill out. And more importantly, the Treasury Department wants a separate form for each way in which bonds are titled. So if you send us just a copy of all the bonds that you have, we can prepare the paperwork for you to make sure that that transfer is effective. The other reason that you want to send us a copy of all of your bonds is that, don't you know, once in a while more frequently than it should happen, the Department of Treasury or someone along the way, like the Postal Service, loses your bonds and loses your transfers. If that happens, having copies of them is going to make it a lot easier for you to prepare what's called a lost certificate affidavit so that you can get those certificates replaced, and more importantly, for the process to make sure that those certificates are transferred into your trust. Life insurance is the next asset. And there's actually going to be two things that you're going to do with most life insurance policies. The first is that you're going to change the ownership of most life insurance policies to the trust. The second thing you're going to do is change the beneficiary of the life insurance. Again, at some point to the trust. Now, if you're married, the primary beneficiary of the life insurance is usually your spouse. If you're the insured and you were the owner, you're going to change the beneficiary so that your spouse is the primary beneficiary. The trust is normally the contingent beneficiary. With the ownership, we're going to change the ownership to the trust for all of the life insurance policies. And I should say most life insurance policies. There are exceptions to this rule, and the way you will know that when these exceptions apply is that a life insurance company will alert you. It's unusual these days that we have this problem. And I'll explain later, by the way, why we transfer ownership as well as why we transfer or change the beneficiary of the life insurance. And that's 7 and 8 on that form because that's the life insurance beneficiary and that's the owner of the life insurance or an annuity. Annuities work very much like life insurance. The challenge with all of the assets that we've talked about so far, stocks, bonds, the mutual funds, any type of life insurance or annuity, is that they can be either qualified or non-qualified. Qualified just means that they're a retirement plan, an IRA, 401k, SEP, TSA, KEO, some form of investment in which you are not paying taxes on the interest, and in fact may have had a tax deduction on settling that particular investment. Now, with qualified monies, we have to do something a little bit different because generally we don't want to change the owner of a qualified plan. The moment that you change the owner of a qualified investment, you run the risk that the investment becomes taxable and you lose all of the tax deferral benefits of the principal when you remove it from the qualified plan. So generally with retirement plans, IRAs, 401ks, KEOs, SEPs, annuities that are qualified, we're not going to change the owner. We're simply going to direct those by way of beneficiary change. And again, as with all of the previous investments that we've talked about, you're going to deliver the change form that we provide to you, and then you're going to confirm that that change was made either by receiving a letter from that company or verifying it on your annual, quarterly, or monthly statements. Now, the next topics are insurance policies. And there are generally two types of insurance policies that almost everyone has: homeowners insurance and automobile insurance. And what we're going to do with both of those is we're going to add the trust as an additional named insured. But wait, Mr. Donohue, my insurance policies aren't going to go through probate, right? Why do I have to do anything with my insurance policies? Well, remember that we're not just avoiding probate as an objective of your trust. We may need to manage these policies at a time when you're incompetent, incapable, incapacitated. And so having the insurance policies in the trust makes some sense. But more importantly, if you are the only insured on these policies and you die as a result of a covered event, an automobile accident, a storm, a tornado, a flood, well, in those situations, the claim that is going to be made is going to result in a check that is made out to you, but you are deceased. So the only way I can collect those checks and pay those proceeds to your heirs is if I probate those checks. If the trust, however, is an additional named insured on those policies, then all your family will simply do is take a check that is written to you, return it to the insurance policy, the insurance company, and ask that they draft a new check in favor of the additional named insured, the trust, and we don't have to take an insurance proceed through probate. You might think that this is not likely to happen. Statistically, it's not, but it does happen. And if it does happen to you, everything we've done to try to avoid probate has now been compromised by the fact that we didn't completely fund our trust. Now, the next item are business interests. You may have a limited liability company, a corporation, you may have a partnership, you may have some other form of business entity or an arrangement, like with a syndicate. If that is the case, we're going to ask you enough information so that we can prepare for you an assignment of that business interest. So whatever interest you have is in the trust. This sometimes can be a little more complicated than it may first seem because, of course, these business arrangements are subject to rules. For example, if you have a limited liability company, you should have an operating agreement. If in the process of my representation, you find out you don't have an operating agreement, you need one. The reason you need an operating agreement is that a limited liability company only provides limited liability. The reason you have that company if you obey all corporate formalities. If you do not obey corporate formalities, if you don't do the things that are necessary to completely establish the limited liability company and keep and maintain the limited liability company as a separate entity from yourself, by, for example, creating an operating agreement, you may find that your limited liability company doesn't do what it's supposed to do. It doesn't provide you asset protection. So as a result of those operating agreements, or as a result of a set of bylaws in a corporation, there may be restrictions on your ability to transfer either your shares of stock or your units of ownership in a limited liability company. If that is the case, we're going to ask you generally to send a copy of those to us so we can take a look at them. And if that's the case, we will provide you with what may be necessary in order for you to transfer those interests, whether that be consent of other interest owners or stock owners, or whether that be an amendment of your particular agreement. For the most part, however, in most family situations where these business interests are closely held, it's not really a big problem. But regardless, the good thing about funding a trust with an attorney that can answer questions, review documents for you, is that we can make sure that when we prepare your trust, that your business interests are properly transferred into your trust. The last subject regards personal property. And this is a subject that is sometimes confusing because a lot of folks think that they have to list their personal property in order for it to be in the trust. And that's not true. In fact, listing anything in your trust, discussing anything in your trust, mentioning anything in your trust may not be dispositive of whether it's in your trust at all. When you go back to the first thing we talked about, property interests, in order for you to transfer your real estate into your trust, you actually have to transfer it by way of deed. There is no other way to effectuate a transfer other than by deed for the purposes that we're trying to accomplish in settling your trust. So if you have personal property, simply listing it is not what's necessary. We do two things. We recommend two things. And actually, the paragraph in the bottom suggests the first thing. We suggest, in an abundance of caution, a comprehensive transfer document, which, although not an instrument of conveyance, states clearly your intention that all of your assets be governed by your trust, as well as a general conveyance of property into your trust. And of course, the next thing is that general conveyance, and that is a personal property transfer assignment that should transfer all of your personal property to your trust. One of the things that you'll notice if you have a new trust is that you have to sign that personal property transfer twice. At first, as the person making the conveyance or the assignment, and then as the trustee of your trust accepting that assignment. If you have an older trust, one of the things that you should do to make sure that it is properly funded is look at that personal property assignment. In the past, in the old days, we used to do a simple transfer that simply assigned all your personal property. And that probably will work in most cases. But we've had two instances in the past 30 plus years that I've been practicing where having that simple form and not having an acceptance of the trustee actually created a problem. In both cases, assets had to go through probate through either a failure to fund the trust properly or because of other circumstances. Maybe it wasn't a failure to fund the trust, it was an asset that was purchased right before death, and as a result of which the asset was never put into the trust, or in one instance, it was actually a dispute regarding title to property, and because the person had passed away, it was filed in the probate court. Now, in both of those instances, not having the conveyance form signed twice, both transferring it to the trust and then having it accepted by the trustee, created an issue. One wasn't a problem, but in the other one, it became a really big issue. And that is that we had to probate all of the personal property. That was a particularly egregious situation because I don't think that most probate judges would have required that particular outcome, but a probate judge did. And it was within his power and authority and his right as a judge to do that. So, in an abundance of caution, in the modern age, when we execute a personal property transfer, we recommend that it be signed, transferring the property, and accepted by the trustee, acknowledging receipt of that personal property. The reason is because the law is technically that personal property has to be accepted or received. Now, generally, when we have an individual, you having the property and you carrying it under your arm out of whatever establishment you purchased it from establishes that receipt. But when we're talking about a trust, the question becomes, well, what acknowledges that receipt? Which is why we have a more nuanced transfer in the modern age. Once you have completed all of the items on this checklist, and that may take you a little bit of time, but generally within 2 to 3 months from the signing of your trust, you will have not only transferred all of these assets, but you will have verified that the transfer was conducted or accomplished or prosecuted, whatever the case may be. And you will then know that all of your assets are in your trust. And just like that, I'm back. I hope you found this video interesting. More importantly, I hope you found something valuable in this video to help you orient or implement your estate plan. It is important if you have a trust, whether it's drafted by me or drafted by somebody else, it is important that your trust be effectuated by funding your trust properly. If it is not properly funded, while you may get some benefits of the trust, you may still be worth the time and effort and money that you put into it. You may lose a benefit, and that's particularly troublesome if we're talking about benefits during your lifetime, such as guardianship protection or asset or aging in place. I hope you found this video interesting. More importantly, I hope you found something valuable here to orient your estate plan. Please stay safe and be well, and God bless you.